Why you can't replace live witness testimony with just a written statement. People often ask why witnesses can't just submit affidavits or written statements to court instead of coming to court and testifying, especially when testifying is often inconvenient, stressful, or intimidating. And the short answer is that written statements cannot be tested, or at least not tested very well. A statement offered to prove what it says is hearsay, and even when courts allow affidavits or verified declarations to be filed, that doesn't magically turn paper into reliable evidence. Credibility matters, and credibility can't be assessed on a page. Cross-examination isn't a technicality, it's the mechanism that exposes exaggeration, omission, honest mistakes, and outright falsehoods. That's why in contested matters, if the other side wants a question to be posed to a witness, the witness still has to appear, live, under oath or affirmation, and subject to real-time scrutiny. Affidavits or declarations show up most often in temporary or motion practice where courts are making provisional decisions with the expectation that disputed facts will be tested later. But when a court is asked to resolve real disputes, custody findings, credibility battles, allegations of misconduct, the rules tighten for a reason in court. Stress and inconvenience don't override due process. Courts don't require live testimony because they enjoy making people uncomfortable. They require it because untested statements, however sincere, are unreliable. If a fact truly matters, someone may have to testify. There is no written workaround for that.